Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, shall be heard. God save these United States, great state of Florida, and its honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning. Welcome to the Florida Supreme Court. Before we begin with our case here today, let me just inform you that each year we have here at the Florida Supreme Court what we call the Justice Teaching Institute. And we invite a number of teachers from around the state for about a week where the teachers learn about our judicial system. And they participate in a case such as this one, and then hopefully go back and teach our children about our judicial system. We have 29 teachers here today who are participating in the Justice Teaching Institute. And they're present. If you would stand, please. Thank you. And Justice Lewis has been in charge of the Justice Teaching Institute for the past, as far back as I can remember. And thanks to him, we have it every year. So on that note, we'll proceed now with our case here today, McAdams versus State.
May it please the court, I'm John Klawakowski, I represent the state. This case is Michael McAdams was convicted of first-degree murder of his estranged wife and her boyfriend, Ryan Andrews. He was sentenced to consecutive life sentences. On appeal, the second district reversed and remanded. They bifurcated the confession. The confession was played for the jury, and what the second district found is up until he was in custody, Halliburton did not apply. Once he was in custody, Halliburton then applied. They reversed the post-Miranda statements. So that's why we're here. We're here on a question of great public importance. The question is, it's a little awkward, so I've tried to rephrase it. The court can not look at it, but the question is, does a suspect who's not in custody and voluntarily speaking to police have a due process right to be informed a lawyer has been retained by his family and wishes to talk to him? Now, when we're talking due process, we look to this court's opinion in Halliburton for guidance. But Halliburton was about offensive police conduct. Halliburton was about ignoring a court order. And Halliburton doesn't discuss non-custodial settings.
But now, in fairness, Halliburton, there's the circumstance of a court order that's referred to there, telephonic court order. But the reasoning of Halliburton is broader than than would be suggested just by the focus on a court order, isn't it?
I would respectfully disagree with that. In '97, this court in Smith mentioned this conduct was not as offensive as Halliburton. So this court in '97, which was a lot more recent than '85 and '87, did. But interestingly,
What was the conduct in Smith?
Smith was actually worse, but he was retained, and a public defender just showed up at the court and said, I'm representing him.
Well, there was a little-
He was not in custody yet.
Well, but also, it was like just a lawyer walking up to get involved in a case.
Correct.
In which the lawyer was not in the case.
But this court in Smith mentioned there was no offensive conduct by the government as there was in Halliburton. Now, interestingly, the same day that Halliburton 1 came out, this court issued a similar opinion in Roman versus State. And Roman is in the second district, McAdams' opinion, as far as custody. But Roman was issued the same day as Halliburton 1, and in Roman, this court treated non-custody and custody totally different. Halliburton was in custody. Halliburton went to the Supreme Court, U.S. Supreme Court, came back. This court did due process. Roman,
I'm sorry, go ahead.
Roman, the same day this court issued Halliburton, this court issued Roman, and they distinguished Roman by saying, Roman, we all cite as far as you're not in custody just because you're in a police station, and that's why the second district cited Roman. But in reading Roman, Roman also applies to the certified question, although it does not talk about due process. In Roman, Roman's sister hired an attorney, and this court says Roman was not in custody, and the fact that the police did not notify Roman that an attorney was trying to reach him was not error. So that's as close as we can come to this certified question, even though we didn't talk about due process.
Let's look at the facts in this case. At what point in time would you say McAdams was in custody?
McAdams was in custody when he made the admission of, I shot them. And we'll grant that he was in custody.
Well, what will you do with all of the other factors? How about 3 police officers going to the bathroom with him? Is that not some inference of control?
The dissent even explains what happened with that. Even the dissent agrees that's not a factor.
Well, whether the dissent agrees or not is not the point.
But
that's one factor. Did they not confront him with blood on his shorts?
And again, we take issue with the dissent saying they confronted him. They told him about evidence, not about evidence convicting him.
How about when they say this is really, really bad? Really bad.
Well, but you're going from a reasonable person standard, and this is a reasonable innocent person, not a reasonable guilty person. And of course, Mr. McAdams is thinking, of course, I did it. This DNA is going to tag me, but that's not a reasonable person standard. And the dissent even acknowledges the fact that 3 officers went. This was not their house. This was not their police station. So they had to be directed to the restrooms too.
So when do you contend that this defendant was actually in custody?
He was in custody when he made the admission of, I shot them both.
What was it?
So where was, you contend then that the police officer who knew that a lawyer was there, a minute or so later, comes in, gets rid of one of the officers, then starts to confront the defendant with the bloody shorts, whatever other evidence there was, and at that point, you don't believe that the defendant was in custody?
He's not in custody because he's made no incriminating statements. This is a missing persons investigation, similar to Pitts. Similar to Pitts.
When he asked him, he said, well, he was about to confess. He said, well, can I think about it a few days? Was he free to leave at that point?
He was free to leave up until he made the admission of, I shot them. And Pitts was a lot more egregious than this case.
Well, I was under the impression that he asked, am I going to be able to go home before he confessed, and the officer said, we don't know.
The officer said, I don't know.
How do you say he's free to go home? That's just directly contrary to what the police officer said and admittedly said.
And the same answer is given in Pitts, more egregious, because in Pitts, they're even saying that, I know you were there. He never says, the officer never says, I know you were there.
We're talking about free to go home.
He was
That's
free to go home.
That's one of the elements we look to.
And the 4 Ramirez factors, yes.
And one of those factors said, is he free to leave? And the man asks whether I'm free to leave, and can I go home tonight? And he's told, well, we'll have to wait and see. That's not a yes, you're free to go.
That has already been dealt with the case law. Pitts has already dealt with that.
How's it dealt with that?
In Pitts, they're even confronting him, I know you were there.
That's not whether
happening
you
here.
can go home.
He's confronting him with the evidence, and actually McAdams offers up, he's the one, when the female detective leaves.
It won't help you to avoid the question, because I really want to know how I can, in good conscience, write a sentence that says, when a police officer says, I don't know whether you can go home or not, that under Ramirez is, you're free to go. How can I do that?
The case law establishes you can be deceptive, you just cannot confront him with the evidence of guilt. And they didn't. They confronted him with the evidence they had. They didn't know what they had.
If there are no cases, why don't you say there are no cases?
I think Pitts is on point.
Does it have in Pitts a question where the defendant asks, am I free to leave?
He says, can I go? In Pitts, he says, can I go home? And the detective says, I don't know. So the same question.
The same exact scenario.
Same exact scenario. Actually worse than this case, because
and in Pitts, we held that there was not in custody.
Well, Pitts was a second district case, but it was review denied. Pitts was a second district case.
Let me ask you about the timeline as to when things occurred here. Detective Airy
Yes.
confronted him alone in the room and told him, we have, quote, we have tons of blood evidence, end quote, and tons of DNA. At the time she said that to McAdams, when was it that the lawyer came knocking on the door, came to the jail?
It was about the same time.
About
the same time.
So at the time,
the record's not totally clear, but we don't have a transcript. We have to watch it. I'm sure you had to watch it too. So we're timing it.
So at the time that he was told that they had a ton of evidence against him, the lawyer was already trying to see the client.
I believe so. I believe so.
See, well, the detective says so. The detective
Yes.
says he knew that the lawyer was out
Was there, and actually
and that seems to me that seems to be his motive for going in and then telling the female detective, you go out, I want to just talk to him alone. It was right after he found out that the lawyer was there wanting to see the client.
When you watch the interview, the male detective has a much more better relationship with the defendant than the female detective was.
No, that's not the point of what Justice Quince is saying. The point is that we're looking at an issue of whether this guy goes there voluntarily, he wants to help in the investigation. The parents hire a lawyer. Lawyer shows up and says, I would like to see my client. I want all questioning to stop. They are told, he is told, no, you cannot see him. And at that point, and it looks pretty, I mean, again, 204 is when this is happening, 205, Justice Quince says, all of a sudden the tenor of everything changes, because what they realize is that they now have a very short time to try to get a confession out of him. And what happens, and it happened in Ross, and I think this is similar to Ross in certain ways, the police seem to think that what they do is they wait till they get a confession, and then they issue the Miranda warnings, because now they've gotten the confession, whereas Miranda is supposed to be given when custodial interrogation begins. Now, in this case, it therefore seems that what has happened, and we are allowed to both review the facts and then draw our legal conclusions, is that the police obstructed the ability of his attorney to come see him in an effort to then get this confession out of him and then decide, then I now have enough to arrest you, now it's custodial. That is not the purpose of Miranda, and it seems to me that there is both a due process violation here as well as a Miranda violation that occurred coincident at the same time, which was around 205 when the custodial interrogation began. That's much more logical than saying we're going to allow police to disregard allowing an attorney to come in and then later on get the confession and say, okay, now we're going to tell you there was an attorney here a half hour ago, you can go talk to your attorney.
This was an ongoing missing persons investigation, and the tone of the interview was non-accusatorial. He was a buddy. He even said, "Sorry, buddy, I let you down."
But what is it, again, is it just coincidence that when the attorney shows up and is told that he cannot see his client, that at that point the female detective is told to get out and the male detective moves closer and starts this accusatory questioning? That's just coincidence that that was happening?
What matters is what Mr. McAdams is thinking at that, what a reasonable
And that's
person
why
would be
the questions
thinking.
that were asked by Justice Polson, Justice Labarga, and everybody else is that he says, I'd like to think about this for a couple of days. And he goes, oh, buddy, you can't think about it for a couple of days.
Well, but again, nothing confrontational in that.
Well, think
Nothing
about-
accusatorial.
Think about this line of questioning. Airy reminded McAdams that the evidence was all there, and the situation would not go away. McAdams asked if he could have a couple of days to think about the situation. Airy replied, regretfully, everything's already set in motion, and reiterated, it's time, Mike. It's just not going to go away. When McAdams asked, am I going to be able to leave here today? Airy responded, I don't know, Mike, I don't know.
And the case law allows for interview techniques like that. The case law for...
But what other case do you have, other than Pitts,
Well-
that you rely on where, let me make my question clear, where there's a statement or a question by the suspect, can I go home, or something like that, and then there's an equivocal response? Because admittedly, what the officer said was equivocal. It's
Right.
not a yes or a no.
As
It's
well he
equivocal.
should do, right.
But now, but let me say, in Pitts, it's really a little different there, because what happened in Pitts is the suspect, Mr. Pitts, said, can I go home if I tell you what happened, or will I go to jail? Well, obviously, that depends. I mean, and that's what the officer said. It depends on what you tell me.
And that's the truth, because...
But that's not what happened here.
We don't know what we have.
You didn't have this kind of question about what will happen if I tell, will I be able to go if I tell you what happened, which requires an equivocal response, but a question about, can I go home? Am I going to be able to go home? Which doesn't necessarily require an equivocal response. It's not contingent on what is said subsequently. Do you understand the distinction?
I do, but there's nothing else the officer could have done at that point that would not violate Miranda, other than saying, I don't know.
Well, what do you
Because
mean
he didn't
He
know.
could have said. He
He did
could
not
have
know.
said. And I'm not saying he's required to, but obviously the officer could have said, "You are here voluntarily, and you are free to go." If that was the case, or even maybe if it wasn't the case, he could have said that.
Right.
So I don't know how there's no requirement that he give an equivocal answer. I understand why the officer, from his perspective, would give an equivocal response. But so my question is, other than Pitts, which I think is distinguishable on this point, what other cases do you have where such an equivocal response was given in response to the question, am I going to be able to leave? I mean, that where it has not been found that there was a custodial interrogation.
That's just one Ramirez factor. There are four.
I understand, but do you have any other other cases that help you on that?
I think I have the case that's on point. I think Pitts is on point because Pitts is a missing persons investigation.
I will tell you, I disagree with you on that, because if you read it, I don't know how you can think that it's the same situation when the question is a different question than was posed here.
Well, I think Pitts is a missing persons investigation, and all the detective knows at that point is something bad happened in that house. I have 2 missing people. That's all I know. And Mr. McAdams is indicating he wants to help find his estranged wife.
But when he asked the question about going home, if that was still a voluntary, if he was still at the police voluntarily, then the answer should have been, yes, you can go. Otherwise, you're in custody, isn't it? Isn't that the case?
He said, I don't know. It depends on what you tell me. If he says, I have an alibi.
No. It wasn't what you told me. He said he was, before you tell me anything, can I think about it, whether or not I should tell you this? I want to go home a couple of days and think about it.
Well, he said it several times, yes. It all depends. We need to talk this out. And again, at that point, there was nothing incriminating stated.
I think what we're also, I mean, we're talking about where a custodial interrogation
Correct.
starts. And ironically, it's also about when the attorney was there. My question, and so the attorney issue, to me, frankly, I have, and I don't know whether where we would go on this, but it seems to me when an attorney shows up to represent a client, and it's a voluntary interrogation, that the client or the defendant ought to have a right to see the attorney that shows up. I mean, I think that that if it's truly voluntary, why, just like they say whatever they're saying, why wouldn't they tell the defendant, your parents just hired an attorney, do you want to see this attorney?
No case in this state has allowed for
I
that,
understand, but
and only New York State has such a bright line rule.
I understand that, but I'm saying that we're here as looking at this other issue would be you can tell them when custodial interrogation starts. It seems that the police are a little, they don't think this is custodial interrogation, and we do. So we're trying to, if we don't have a bright line rule, it would mean that that at 2 o'clock the attorney's told you can't see the client. Now we're going to we're putting on the pressure, you can see the client once we have a confession. That's what that's how once we arrest him, then you can see your client.
When he's not in custody, there is no, you have to look at Halliburton for a due process violation, and you need to have offensive government conduct that interferes with an attorney-client relationship. You have no relationship yet. You're not in custody.
You're interpreting Halliburton, I guess, very differently than I read it. And
as the second district read it, as you did, too, for the second half of it.
Do you see what's happening here? You know what's happening here is the state taking such a rigid position that it's almost pushing that the principle of law, to be workable, is going to have to go before you're even in custody. You have a right to it. The questions have been coming along the lines of, okay, well, maybe this is a good rule of law once you're in custody. But if custody is so difficult under the facts that we see after looking at the tape, maybe it's unworkable to have a principle of law that says you're only entitled once you're in custody to talk to your lawyer. I'm beginning to, I walked in this morning thinking that's probably a good rule of law when you are in custody, but after hearing this argument, I think it's a practical matter that's impossible to work.
It's procedurally impossible to work for a law enforcement purpose also because you have no due process right. You come there voluntarily. You can leave voluntarily. Until you're in custody, you have no attorney-client relationship either.
Well,
so there is no.
The problem is, if you're there voluntarily, do you have to ask to go to the bathroom?
He needed directions. As the
detective
needed directions,
too. Do you have to ask to go to the bathroom? If you're there, you just get up and go to the bathroom. I go to the bathroom. I mean, at some point, voluntary becomes involuntary, and that's when
the kid was. He's 40.
He's not a kid.
He's
right.
17 years old, and his parents come to see him with an attorney.
It's a whole different ballgame when you're dealing with minors, and I think the certified question does mention this is for a non-minor. I think that's a totally different ballgame too, but of course, it's a different rule for minors.
Listen, your time is up. You used up all your time.
Oh, wow.
But we helped. Well, we helped you use it up. So what I'll do is I'll give you 3 minutes when you come back for rebuttal.
Thank you, I think.
Thank you. Maybe not.
May it please the court, I'm William Shawwell. I represent Mr. McAdams. First of all, as to the Roman case, I'd like to point out that was not decided on due process grounds. Mr. Roman was read Miranda before he gave the statement. That would distinguish Roman. This case was decided on due process grounds. It's my position that the due process clause of the Florida Constitution should be interpreted to require that people in Mr. McAdams' situations, I believe he was in custody, but whether or not he was in custody, when you're held incommunicado, where you can't get to the area on your own. You have to punch a key code to get into that hallway. He went into a special entrance for police to the station, and where members of the public can't access it, I believe he should have been told of the lawyer hired by his parents to represent him.
So your argument really is, at any point, he's at the police station, a lawyer representing him comes, he should be told of that?
Yes.
So what about if the lawyer simply calls the police station and says, I'm representing Mr. McAdams?
I think that would be sufficient.
You think calling would be sufficient also?
Not calling the police, but they have to communicate the fact to Mr. McAdams that a lawyer is ready to assist him.
It doesn't, these issues we've had, I mean, the Halliburton case was pretty, it's in Palm Beach County at the time, and it doesn't seem like that happens a lot. That is, that there's an attorney that's hired by someone that actually shows up. And so from your experience with, and then we have the situation where a public defender really isn't representing them but just comes. And do you agree that's a different situation?
Yes, Smith and Harvey are a completely different situation. I'm not sure how often it happens. I've been a public defender for almost 20 years now. I was in private practice for 2 years, and I can't think of a case where I went.
So it's really this, but the issue, and this is what Justice Lewis was asking at the end of the questioning, and this is my problem, and it's a friendly question, which is that if a lawyer shows up and someone's truly in a voluntary interrogation, the idea that the police will say you cannot see this person seems offensive to me, but I'm not sure it's a due process violation. I mean, I'd like to know if I'm there and my parents hired someone for me, I'd like to know that there's a lawyer I could talk to. So how is it how is that a due process violation under the Constitution for the client or the defendant not to be told that there is a lawyer there to see him?
I think it's misleading the defendant by deception. I mean, Halliburton...
By omission.
Omission, I'm sorry. Halliburton talked about both types of deception. And I think in order to ensure a full waiver of the right to silence and the right that you're free to leave, that it would be better off if the suspect is told in this situation.
Let me ask you this. I mean, what is the role of the police officer in determining whether someone has been actually retained to represent this defendant? What happens in the situation, for example, I'm a lawyer and I find out that a friend just got arrested. Nobody has called me to represent him, but I show up at the jail. I'm a friend. I want to make sure, he's advised of his rights before he talks or whatever. I mean, how does the police distinguish between someone who's been retained and not retained and someone that just wants to do the guy a favor?
I think the difference is that if the lawyer says he's retained by the family, he'd be subject to Florida bar discipline and other issues if he lied to the police about that.
Well, what if he just said, I'm a friend. I'm a friend of his. I just dropped by. I want to make sure that he gets legal counseling before he talks. I mean, does the police have a duty at that point in time to stop the interrogation and let me talk to him?
I don't think so. I think the difference is a lawyer hired by your family, somebody who has your best interest at heart. I mean, you could also have the situation where a co-defendant or somebody else hires a lawyer, like a drug conspiracy. I think the fact that the lawyer is hired by the family, I think that's the difference.
I mean, I was a public defender for a number of years, and I remember in homicide cases, the public defenders knew that eventually that case would they would end up being appointed. And they knew he was being interrogated, and they would try to go over there and get in to see him. I mean, in that situation, does the police officer have to let the public defender who's not been appointed yet?
No, this court in Smith and Harvey said no. I mean, then it makes the difference between an abstract lawyer mentioned in Miranda and somebody...
What's abstract about a lawyer that I'm the defendant's friend, and I go out and find a lawyer, or hire that lawyer, and send them over, and that lawyer goes over to the jail? Isn't that the same thing as the family hiring a lawyer?
I think it's different. I think the family definitely has your best interests at heart. Friends usually do, but you can't always tell.
But I don't understand how this relates, that these distinctions relate to due process of law, which is the theory under which this is all traveling. In some ways, it's a little troubling to think that someone whose family's got the money to go get a lawyer can send them down there, and then the lawyer can get a message through. Whereas if someone who doesn't have the advantage of a family who can go hire a lawyer, can't get the advantage of a public defender who is in the due course of things going to be appointed, who would try to help provide counsel when this interrogation is going on.
I would have no problem if this court walked away from Smith and Harvey, but I don't think you have to in this case.
I mean, we have all, unfortunately, we have all situations here, although we say everyone's equal under the law.
Yeah.
If this was a defendant who had trouble with the law before, and and his family was whatever, he probably would have already had a lawyer and would have never gone down to the station.
Right.
So, I mean, I think we get to this, the naive, we understand the reality that the police, for good reason, in their investigation, does not want a defendant to speak to the lawyer before they, quote, voluntarily question them. Now, let me ask you, going back to the issue of when your view is when custodial interrogation started, do you agree with the dissent in this case?
Yes.
Okay.
Yeah, see, what happened is, you know, about 148 or 149, Detective Christensen mentioned, you know, we've been at your house, things don't look right.
And can I ask you on that one, when did they have this sort of, did something happen in terms of the development of the evidence from the time they went to his house, because obviously he's going to be a main suspect, you know, they know that, they were going through a divorce, and when 2 o'clock or whatever, when they start confronting him with what they do have? Did something happen? Did they get evidence back? What does it show about?
They had executed a warrant that night. In fact, Detective Airy, during the interrogation, tells Mr. McAdams, look, I was at your house till 3:30 in the morning. Mr. McAdams...
At what time did they tell him, what I'm asking, okay, when they go to the house, do they tell him at that point that there's DNA evidence?
No, I mean...
And they don't have to, but
no,
I understand.
No, Mr. McAdams, the detectives doing the interrogation that you all saw in the video were Pasco County detectives. What happens is Mr. McAdams was met by Hernando County detectives. The house on Glover Road was in Hernando County. And they were assisting, and they had assisted in execution of the warrant the night before. And apparently he had been out alligator hunting, and he was driving poorly, and I'm not sure exactly what happened, whether somebody who had heard about his driving poorly pulled in, but shortly thereafter, the Hernando County detectives showed up, said, look, I mean, they want to talk to you, you know, the Pasco detectives want to talk to you. You can take your own vehicle, or if you want to save gas, ride with us.
Okay. So again, he gets to the station. When is it, does some new evidence come to light between when they started questioning and when the break occurs where the lawyer comes, they say you can't see the client, and the male detective starts the different questioning? Did they get more evidence?
I'm aware of nothing.
So it really just was a change in deciding to ramp it up.
Right. I mean, it was like a light switch at that point.
Because I mean, again, and listen, they know that there now may be a lawyer.
Yeah.
And I mean, this is, again, and all, we're not, you know, attributing, quote, bad motives to but at that point, would it be your view they should have given him Miranda?
Yes.
And you have a right to a lawyer, you actually have a lawyer here.
Yeah. I mean, they didn't have to read him Miranda, but they could have read him Miranda at that point, like they did in Roman. I mean, they read Mr. Roman Miranda early on.
Where is it? I mean, there are a lot of things said to this is a long interview that goes on. And there is definitely talk about evidence. There's talk about strong evidence. But is there anywhere in this whole sequence of conversation where the law enforcement officer ever says, we've got evidence that shows you did this crime? There's nothing like that, is there?
No, but they list certain circumstances. They don't take that final step.
Okay, they do not take that final step. And so when they talk about there being strong evidence, I mean, it's clear that he would have understood that they thought a crime had been committed.
Yeah.
I think based on the discussion. But as far as something that directly confronted him with evidence that they had that he had committed the crime, what's the closest they get to that?
That there's blood on your clothes, and then they told him that his explanation for the blood was incorrect.
See, that
When did he make the statement about wanting to, am I going to be allowed to go home? Was this at the beginning of the lone detective's questioning of him?
Not quite. Let me find that out.
But, well, I guess the detective goes in there, tells the lady detective to leave. He starts talking to him, and instead of the defendant answering the questions, the defendant asked him, am I going to be able to go home?
At 2:11.
This is after the blood, after he confronts him with the blood evidence?
Yes.
Okay.
Yeah, I mean, you know, the evidence is strong. They say something about there's blood at her house, at your house, there's blood on your clothes, and then they tell him your explanation for the blood is wrong.
So is that the point where the custody begins? I mean, assuming the lawyer, we're putting the lawyer issue aside for right now, but did the custody part of this really begin when the defendant is now essentially told he's not going to be able to go home?
Yes. I think you could find him in custody even earlier when he said, look, when there's that, it's about a paragraph.
Well, you agree, I mean,
Well,
you got
you mean the
Judge Davis,
confrontation?
you got Judge Davis helping you out on
Yeah.
this, was saying that at the point when, at 2:04, when whatever it is, which is when they know there's the attorney there, they come back in, you said they already had known this, and that they advised the evidence is really strong. We found tons of blood evidence, including blood on the T-shirt belonging to you. The male detective stating, I've already got a pretty dang good idea of what went down. And when he said it was rat blood, the male detective retorted, no, it was determined to be human blood. But, so that's a 2:04.
I think that's the point where you could find him in custody earlier.
Well, that's, again, you could just say you agree with Judge Davis,
Yes,
unless you want to.
No, I would definitely agree with Judge Davis.
Well, don't we in these cases, it's not necessarily like always just one magic question, but it is a string of questions. The questioning becomes accusatory.
Yeah, it's a
and there's multiple questions.
It's a totality of the circumstances.
that come in.
I mean, of the Ramirez factors, the first one is the one that cuts in front of the state. And the beginning part of the questioning, the first 45 minutes or so, or maybe slightly in and out, it's like they're just trying to establish a timeline. And some of the cases talk about conversational or investigational,
right.
And there's a switch to accusatory.
Right. But as we're looking at the practicalities of this, we're going to have to come up in these cases, it appears, with a principle of law for application in the communities all across the state. And you're taking the position that it is at custody. Well, it can be seen, I mean, how different the views of when custody attaches can be. And then we have the question, the overlay of a lawyer coming into that scenario. So are lawyers supposed to just come and wait at the police station from 10 o'clock in the morning until 10 o'clock at night, waiting for when the police decide, okay, you're in custody now? I'm troubled about just the practicalities of how does this work? What if the lawyer comes and says, I want to talk to him, but he's not in custody yet, so the lawyer leaves. Then we reach custody, there's no lawyer there. So are we just extending this thing? Are we just by placing it on custody, encouraging more and more litigation rather than resolving how a fair criminal justice system should work?
I think so. If you want fairness in the criminal justice system,
is that what we're here for?
Yes, the New York rule. It's clean cut. There's not a lot of ambiguity in it. I mean, a lawyer enters the case by saying, either physically showing up or calling, saying, I'm here. And even if they can't even question somebody in their own house at that point under the New York rule. The New York rule is a bright line rule. And I also think this issue is important to avoid false confessions. And we've seen a lot of cases by the Innocence Project kind of cases, and I think that's a big deal.
Well, I think that, though, again, we're talking about, I guess, the two things coming together in this case. But I see that this idea that the custodial interrogation started 2:04 or 2:05, 2:08. the point is, in this case, at the very least, it coincided with when the attorney was there.
Yeah.
And if the police say, no, we're not going to let you see a lawyer, essentially until you confess, it seems that that, in this case, amounts to a due process violation. But I think going forward, I would tend to agree that the New York law makes more sense for the reasons that you just enunciated.
It's clear, and everybody can follow it. There's nothing ambiguous about it, rather than doing these things piecemeal by piecemeal.
I mean, now you said something else, because I have seen, I was looking back at Blaine Ross, where we condemn this idea that you wait till there's a confession and then you give Miranda, because you're sort of then undermining the prophylactic effect of Miranda. So in this case, do you see that at the time that the one detective came back in and they start confronting him, when do you think Miranda warnings should have been issued? Were they issued properly in this case, or should they have been issued?
They should have been issued as soon as he was, what I argued in the issue 2, when he was in custody.
Which is?
When he was confronted, you know, either.
So it would, in this case, it would actually end up being at the same result, which is Miranda should have been issued earlier, but practically speaking, being told there's an attorney there, they don't have to then also issue Miranda. They wouldn't have had to issue Miranda.
Right, that's it. If the court has no more questions, I'll sit down for now.
Okay. Thank you. You have 3 minutes if you want them.
I do. Maybe I don't. We'll see. As I stated before, this court already addressed the certified question in Roman the same day Halliburton 1 came out, and this court found it was not error to have a non-custodial suspect be informed an attorney came. So if you're not in custody, you have not had any government infringement, as Halliburton says, and there is no attorney-client relationship. Significantly, there is no custody in this case, and we can debate about when there is custody, but you're giving him more rights than if somebody was in custody, and it's not a workable rule. It's not a workable rule for law enforcement.
How would we be giving them greater rights than someone in custody? I'm missing that one.
That all of a sudden, he doesn't have to be informed that there's an attorney yet when he's given his, he can waive it. Mm-hmm. And in this case, he did waive it.
Well, he could, no, but that's not greater rights. He's told there's an attorney here to see you, retained by your parents. Do you want to see the attorney? He could have said, no, I don't need to see the, this is all, I'm still trying to help you out.
Which he subsequently did do. Right, I understand, but
when was he told there was an attorney there?
After he shows them the bodies. He shows them, and then he's told, and he said, well, what
do you understand,
I do
again,
understand
as we're sitting here, common sense, does it sound
he was
to
told.
you?
But applying a rule like this is unworkable. This court has already ruled on it.
But the point is, it seems very workable to say that when somebody shows up retained by the family, to see somebody who is being questioned where they otherwise can't reach the client, that they ought to tell the client they're there. If he was being questioned at home and the attorney called on the phone, he'd say, just a second, hello, I'm retained by your parents. I wouldn't recommend you continue to speak to these attorneys, to the police. So how is it seems more workable than trying to do it the other way.
Well, not from a law enforcement point of view. And this court already ruled
from a constitutional,
it was not error.
I realize it's not helpful maybe to the law enforcement, but you know what?
Well,
the problem is if confessions gets suppressed because law enforcement does something that seems expedient at the moment, we end up really not helping the interest of justice, do we?
This case, he's not in custody. There's no egregious law enforcement acts. He's coming there voluntarily. To apply this rule to a non-custodial defendant, this court has already said it's not error. So how could it be a due process violation if it's not error?
So it was all just coincidence that once the detective is told that there's a lawyer here who's been retained by the family, that the detective then decides goes in, confronting him with the evidence, something that had not been done, and he'd been there since 11-something, and they'd gotten there close to 12. So we're already into 2 hours. They never confront him with anything, but once they find out that the lawyer is out there and wants to talk to him, they then start to confront him with the evidence.
They had already confronted him with the evidence, and again, it's not the evidence of his guilt, it's the evidence before that 204 timeline. They had already confronted.
The evidence that would point to him.
Well,
They never confronted him with the evidence that would point to him.
By saying there was blood
The dissent
on
is
your
wrong,
shorts?
and I think the dissent in the briefs, it points out that the dissent is wrong at saying the evidence confronting him. It was the evidence, and the detective, please look at the video. It's a very compassionate, bonding relationship between the detective and the
That's a
defendant.
nice psychological way to
becomes so
get
bonding.
Well, but again,
It becomes so bonding that he asked the detective question he should have been asking the attorney. What am I looking at?
But
Give
that-
me your professional opinion. I mean, and when the attorney was there.
but that proves he was not in custody at that point also.
Okay, thank you.
Thank you.
We're in recess. Oh, I'm sorry. Thought we were done.
Get to have rebuttal.
Because it's a cross-appeal.
May it please, briefly, I wanted to distinguish the Pitts case before that we discussed. Pitts was never told anything like, we don't believe your explanation for, and he said, I pawned the property given to me by T.J. Wright. And in this case, Mr. McAdams was told his explanation was not believed by the officer. The blood, that's not snake blood, that's real blood, that's human blood. And I'm asking you to find, reverse, suppress the second confession also. Thank you very much.
Now we can go. Sorry. And yes, I do want to compliment the lawyers in this case for the arguments you're giving. It's a difficult issue. As you can see, we're having trouble with it, and we will hope to do the best job we can. Thank you. We're in recess.